This is a University of Otago podcast.
So I've been an ANZ customer since I was 5 years old. I'm not the Chief Executive of the Commission, I am the Chief Commissioner. The Chief Executive of the Commission worked in the ANZ Bank. It was the National and then the ANZ Bank, in a senior executive role for about 20 years. The only time I left the ANZ Bank, I left because I was pissed off with them. I went to the National Bank and then they bought that to get me back. The one thing I'd say is hopefully by the end of my talk, there might just be one little change, and it would be that it's essential the ANZ strikes the right balance between using data for commercial purposes and human rights. Because privacy and security are two human rights, but they're not the only human rights that are relevant to big data. And the ANZ actually is pretty committed to human rights. Its chief executive in Australia last week just announced that they're going to introduce programs around domestic violence that their employees are suffering at home and do work in the bank to do that. But ANZ's also slipped up on human rights, and it's a little bit like the situation in some of those diagrams when you look at that trade-off between commercial return and risk, and the area that they did it was in Cambodia, where they financed a development project that ended up land grabbing off Indigenous people. And they've addressed that problem, or they're addressing that problem. Their competitors actually had in place, NAB and Westpac actually being lauded by Oxfam as having done the due diligence. So you can see that the banking world isn't just about what you're doing in your business, but what you're doing in your supply chain. What are you financing? So this is the same information that Ben and Tina were sharing, and it really is what this is all about. It is about a question of trust, and big data is being used by government and by business. And you're providing them it in your activities, particularly around social media. So just let me start by saying I've got form when it comes to data. I'll admit I've used it in the past in business and in NGO roles, and I haven't done human rights due diligence. I didn't know what it was. In the 1990s at Fletcher Challenge, I learned about data first really from DuPont around health and safety. And DuPont had a saying, "In God we trust, everyone else brings data." And that's not very human rightsy, but that's what they said. And then in the 2000s, we used those safety principles in New Zealand rugby with ACC to reduce spinal injuries caused by tackling and scrumming. And doing so, we saved many lives now. And by ACC's current calculation, about $500 million in ACC claims for a cost of $1.5 million to ACC. And you read about that in the Lancet. But in neither of those efforts did I use any sort of human rights due diligence. I'm sure we worried about privacy, but we didn't know privacy was a human right. Now, national human rights institutions all over the world are looking to use data in big and small to measure the state's performance in the delivery of what are known as the Sustainable Development Goals, which were only agreed in September. But if you look at some of the stuff around them, you will see that you'll see why people are going to start using data more to measure government's performance on human rights than they are the sort of waffly words that we use today. And in New Zealand, just last week, we finally convinced the school system that it might be actually a really good idea to use data to reduce bullying in New Zealand schools, because they've been resistant to the idea of actually measuring what the problem is. And if you can't measure what the problem is, you certainly can't fix it. But the really important thing to understand is the collection and the use of big data is surveillance. That's what it is, whether it's by the government or by business. And like other forms of surveillance, it can do good and it can do bad. And responsible businesses, people and governments need to ensure that big data does good. Anyone involved in the collection of big data should understand the basic human rights that flow from using it. They must understand the United Nations guiding principles on business and human rights, and those principles should be taught in business schools. Now those principles have only been around since 2011, and if you were all CEOs of New Zealand companies and I asked you what they were, very few of you would put your hand up and tell me. So that it's a new thing, and they're not bad because they haven't done it yet, but it's coming. Now, human rights, in my experience, abuse most often occurs when people are convinced they're doing the right thing, not the wrong thing. So even some of the worst things that have ever happened in human rights, people thought they were doing the right thing. And not last Friday, Friday before, I was flying over Paris right when the killing started, and I was looking down on Stade de France and thinking, oh, it'd be great to be down there with the kids. And when I landed at Geneva Airport, you know, the first reports were coming through. And even at the UN Forum on Business and Human Rights that I was at last week, where there's normally pistols, there were machine guns. It was, you know, it just changed the thing, and suddenly the parts of the Human Rights Conference were all about that. So while I'm going to talk about big data, I'm also going to talk about the human rights issues around terrorism, because it actually is particularly about the human rights around privacy and security. And the issues that we're facing with the government on big data are the same sorts of issues that business needs to be worrying about, just in a slightly different context. And the common link is the surveillance. And there's a need for policy coherence in how we deal with surveillance. And, you know, it's really worth thinking to our history. If we think about the time when we were most terrified in our recent history, that men who were so certain they were right were going to kill us, it was World War II in around 1942, when we were getting thrashed everywhere and had won nowhere. And this is what New Zealand said with the other nations when they made the Declaration of the United Nations in 1942, not 1948, in 1942. They said, we are convinced that complete victory over their enemies is essential to defend life, liberty, independence and religious freedom, and to preserve human rights and justice in their own lands as well as in other lands, and they are now engaged in a struggle against the savage and brutal forces seeking to subjugate the world. So that was what we fought for, that was what we died for, and that's what we're trying to live for now, and there are people trying to take it away from us. And yet at that time, in our most terrified, we said those are the things that matter, and that is what we're fighting for. The victory was achieved at an horrific cost. The big data wasn't around, so there was no issue about big data contributing to the victory, but signals intelligence did. So surveillance did contribute to the victory. So surveillance isn't bad if used for the right purpose. It's not, as some would have it, that there's a choice between freedom or security, or privacy or security. We were and are dealing with people who are too certain they're right, and their version of freedom is that they've got the right to kill us. And the antidote to that is the Declaration of the United Nations Declaration of Human Rights. That's got all you need to deal with that. And privacy was one of the human rights we were defending. And in 1942, New Zealand, Indian and Australian troops at El Alamein, in the first Battle of El Alamein, stopped Hitler. That was the first time anyone did. There were 4,000 New Zealanders in the 12,000 casualties, 3,000 Indians and 3,000 Australians. So that's who put the effort in. And then later that year, those same soldiers joined with the British Army to push them back. And again, just remember, in that exact battle, it was won by signals intelligence. Courage and signals intelligence. So again, surveillance isn't bad or good necessarily, it's the purpose it's used for. And in my mind, little's changed. Technology doesn't change the principles we stand for. Intelligence gathering has, and always will be, a crucial part of protecting the liberty, independence, freedom of belief, human rights and justice. It's not about balancing our security and privacy, it's about protecting our rights and freedoms including privacy and security. The use of big data is no different than the use of personal data if human rights are likely to be infringed. The balance needed to be found is in the recipe in the United Nations Charter and the Universal Declaration of Human Rights and the human rights treaties that we've agreed to. Much of New Zealand's work is built on much of New Zealand's reputation in the human rights field is actually built on the work of the New Zealand Army, whose members defended human rights and freedoms for decades, often in incredibly difficult situations. And there's lots to learn from the New Zealand Army about how to deploy human rights thinking in difficult situations. Anyone working in the intelligence sector or in business with big data needs to have some understanding of the same human rights and freedoms as exists in the New Zealand Army, right down to the frontline soldier who carries in his pocket the 10 things you must know about human rights in combat. And you need the ability to apply those standards in the work you do. And unfortunately, right now, the understanding is not as deep as it needs to be in some areas of government or business. And just to sort of put that in context, in our job, the ministries we have the problems with are the social service ministries, not police or the army. Okay? So it tells you where the training isn't. Now, my life is really shaped a lot by the life of my Uncle William, who was the head surgeon in the A&E department of the Royal Victoria Hospital in Belfast for the entire time of the Troubles. And one time when I was there, I said to him, is there anywhere I shouldn't go, William? This is in Belfast. And he just looked at me with a really steely glare and said, David, you've got more chance of getting killed in London by an accident or a shooting or a knifing than you have by a bomb, bullet or anything else in Belfast. Don't let the bastards own you. And that was a lesson in proportionality and not being driven by the headlines, but being driven by the real underlying data of what the situation was. The other thing he told me I think was really important to think about in the context of terrorism, but in any area where you're using big data, was he always felt that his colleagues in Cook County Hospital in Chicago had a tougher job than he ever had in Belfast. And just to put those in context, nearly 4,000 people lost their lives in the United Kingdom and Ireland in the 20 years of the Troubles. And 220,000 people have lost their lives by gunshot in the United States since 9/11. And where's all the fuss? And where's all the attack on liberty and so on? So, I think the really important thing is something A.G. Grayling said, a professor in the UK. We shouldn't wish for a future. We should not wish future men and women who have to fight all over again for liberty to think we gave up the courageous work of centuries without a fight. And I'd re-emphasise the point that it is absolutely critical that people in intelligence gathering and in other uses of big data get human rights training of the quality that Kevin Reardon, who's the current Adjutant General of the New Zealand Army, has put in place and is used actually not just in New Zealand but around the world. Understanding how to apply the human rights lens to business is not a trivial learning exercise, and I'm not going to pretend to be able to do it today, and nor do I think should the training be delivered by sort of academic human rights people or people from the Human Rights Commission. It should really be developed in-house by people who understand the context that they're working in. It would be completely useless for me to go into the army and try and explain to them the situations they deal with, for example. Now, information technology is now ubiquitous in our lives. We are the people who need to take responsibility for what data we generate, not the business and not the government. We're the biggest problem. When you tick that box on your little phone app, you need to know what you're doing. It's your responsibility. Doesn't help that some of the terms and conditions are longer than Macbeth, I know, but it's your responsibility. The most dangerous thing isn't the technology, it's the person who's using the technology. If that person is really sure they're doing the right thing, it's even worse. And the lesson of the truth of that was in the doctors and nurses who in 1933 killed a disabled child on the orders of a democratically elected head of state who acted on the request of the child's father that the child be killed. The head of state was Adolf Hitler. The doctors graduated to Auschwitz in 1940. But it happened in 1933 because it was a good thing to kill the disabled child because it strengthened the majority of the German race, and it fitted in with the general thinking around eugenics of the time, which was popular here as it was in Germany. Stanley Milgram's experiments show that humans will be obedient to authority when doing harm to people if they think they're doing the right thing. So he got them to apply, they thought that they were applying lethal electric shocks to people who were given the wrong answers to questions. And then in the Stanford prison experiment, they got normal university students to start behaving like the warders in Abu Ghraib in days, because one group was given power over the other. And that's what human rights is all about, really. Human rights is competition law for humans. That's what it is. We are totally capable of being good or bad, every one of us, if put in the right apple box. And it is tough in business, because I've been there, and you can be absolutely sure you're doing the right thing, and actually it turns out to be the wrong thing. So, the stuff around ethics, and that is really important. And information and communications technology is now essential to government, essential to business, and essential to us in our daily lives. The use of that technology and human rights are inextricably linked. The use of this technology and the big data enabled by it has human rights issues that will arise with information and communication technology. Big data will almost certainly offer new opportunities for the realisation of human rights. It will also certainly, potentially, cause human rights harm. And I just want to sort of briefly take you through now the Commission's report, just the stuff on terrorism, and because it's and security intelligence, because it links into big data, and it is all about big data. It's about metadata and all that sort of stuff. So we, in the last 2 years, have reported to the Prime Minister about concerns about security intelligence and human rights, recommending the review that's now underway in New Zealand. We've urged New Zealand to support Germany and Brazil's resolutions in the General Assembly, and they've done that. We've reported to the United Nations Human Rights Committee on civil and political rights issues around surveillance and big data. And we've made submissions to the Cullen Ready review that's underway now. We've engaged with ICT businesses around the world. Because of something I wrote in the New Zealand Herald, Microsoft's General Counsel in New York dispatched a team of lawyers to talk to me in New Zealand. 3 of those lawyers had over 4 years' experience inside the UN system. They had more lawyers on human rights than we did inside Microsoft. And actually those big ICT companies that are concerned about this, and think about Microsoft just last week, created a whole new thing called a data trust, where a German company will hold all the data that Microsoft, so that any US-based Microsoft customer can move their data to there so that the NSA can't get to it because of trust. They don't have a business model unless their customers trust them. The activities of intelligence and security agencies and of banks and others who are using big data can be described as having a twofold effect about human rights. Firstly, they may limit the human rights of people. And an obvious example being surveillance operations on the privacy of affected people. Conversely, they actually enhance the government's capability of meeting its human rights duties to protect people from harm. So it's double jointed. And the use of big data has similar effects. The Snowden disclosures and the reviews of the intelligence services all over the world have led to a complex, polarised public debate, both in New Zealand and internationally. And in his review of the United Kingdom's intelligence and security legislation, David Anderson QC described this as double jointed. Basically dominated by arguments by law enforcement officials and securocrats for more operational capability and fewer restraints on the one hand, and arguments by civil libertarian liberty advocates for safeguards and less capabilities on the other. And Anderson comments that the silent majority, the general public, sit in the between those positions in a state of some confusion. Similar issues arise with big data, and in both areas trustworthiness is key, absolutely key. And at the heart of this debate lies a perception, which we think is wrong, that a trade-off is required between privacy rights and rights to personal security in order to enable the operations of the intelligence and security services. The Commission's view is that such a characterisation is too narrow. Instead, a balanced position can be found within the human rights concepts and principles that underpin the modern democratic state. A similar position can be found in relation to other forms of surveillance, like big data. Indeed, a great deal of government surveillance around the world already relies on big data. And we need coherence, we think, between the rules we have for intelligence services and the rules we have for business. And they need to be simple and they need to be clear. Now, Anderson, and there was another report called the Democratic Licence to Operate report in the UK, done late last year. We think those two reports have got a lot of the answers for what New Zealand needs. Anderson's approach in balancing the complex and competing sets of interests is to place the notion of trust at the heart of the matter, just like these guys did. And noting that if there's one thing that's for certain, it is that the road to a better system must be paved with trust. The Commission considers that in order to earn the trust of the public, the trustworthiness of laws, institutions and practices is a matter of paramount importance in this respect. Trustworthiness is at the heart of the human rights issues around the use of big data. In order to achieve a more balanced, accessible system that more effectively respects and responds to the public interest, Anderson recommends that the design and operation of intelligence and security legislation, policy and practice reflect 5 interrelated principles. And I think these principles can apply to business. Minimise no-go areas, have limited powers of surveillance, human rights compliance, clarity and transparency on what the rules are. I defy anyone to know what the rules are right now, including it must be a nightmare for the intelligence services, and a unified approach. The other panel frames the relationship between the public and the government security intelligence services within the concept of a democratic licence to operate. In business terms, probably a social licence to operate, whereby the mandate of the intelligence and security services is derived with the consent of the people through a democratic process. They've said there were 3 distinct deals in the democratic licence. The first deal exists between the citizen and the state and must be reflected in a clear, transparent legal framework and a coherent, visible and effective oversight regime. The second deal regards an improved shared understanding between government and the private sector as to the role internet and telecommunications companies have to play in sustaining essential principles that govern an open society. And that does include the banks. You know, the banks at the moment, I don't think, are subject to the same sort of stuff that's been going on with the ICT companies, but they could be. And if you've got one bank that's got half of New Zealand as its customers, you know, we want to know that, and they want to know that they can't, their trust and integrity can't be undermined by some government order. And that's where Microsoft is suing the United States government in the courts. And the third deal is the importance of international harmonisation. And you can see that with the bank, but also with the Five Eyes Alliance. You want them all operating under the same rules, and you probably want as many spies as possible under the same rules. And that's where the international treaties come in. So I won't go into there's sort of 10 tests developed for how you might do that. But so we've also noted in our submission the ongoing challenge posed by the exponential growth in collection and use of private data by companies. The UK panel noted that the public is as equally, if not more, concerned with the use of personal data, or the security of personal data with companies, as they are with respect to government agencies. You notice there's pretty bad news in there for the government, in the chart behind me, though, down here. Yeah, yeah, well, it could be. But social media firms, you know, they're in the worst position. So while that concern, if you like, about the business side of big data is actually beyond the review of the current intelligence and security review. We're hoping that Michael Cullen and Patsy Reddy actually say something about the need to do something to get greater coherence between the public and private sectors. But basically our position is summarised like this. We consider there's a strong case for substantial reform of New Zealand's intelligence and security regime, but that the reform should be guided by a principled yet pragmatic methodology that maximises public trust and confidence in the operations of our intelligence and security agencies. If we were being asked about the private sector, we'd be saying the same thing. We consider that the societal changes brought about by electronic surveillance, data interception technology and ICT technology generally requires consideration to incorporating the right to privacy in the New Zealand Bill of Rights. So we've signed an international treaty which legally obliges New Zealand to bring into force in New Zealand the International Convention on Civil and Political Rights, but we have not brought that into force in relation to privacy. The Privacy Act, as it is today, is not the same as a right to privacy. And if it was a right for privacy in the Bill of Rights, I think you'd actually have a lot more grunt. And we've made a lot of other recommendations in the submission, which we're happy to circulate, that will be relevant to the use of big data. But big data will be used to advance human rights. The 2030 Sustainable Development Agenda and the related goals, targets and indicators set an ambitious program of development, and it's also a human rights agenda. Big data, I would say, is going to have a very significant role in the realisation of those goals. However, the incorrect use of big data equally would have the ability to thwart the attaining of those goals. Just to give you an example, that we've looked at the health goal, which I think is from memory goal 4, and we've done human rights analysis of the health goal. And the targets and proposed indicators in the SDGs are really good human rights indicators. And New Zealand has to report on these goals, and it has to disaggregate its report by Indigenous people, women, children, disabled people, and so on. And I think the best thing I've seen on this is a submission by some people at Essex University on the World Summit on the Information Society, and this is what they said. However, the appropriate use of ICT and big data has the potential to both interfere with human rights protections and to undermine the achievement of the Sustainable Development Goals. There are 3 main areas where ICT and big data can act as gateways to violations of human rights if adequate safeguards do not exist. First is the collection, storage, sharing and repurposing of data may infringe the right to privacy. So that is the privacy bit. However, privacy is not the only gateway to the infringement of human rights. Second, issues of consent and repurposing arise when data is used for a purpose for which the individual that disclosed it did not originally consent. These 2 gateways can arise in the context of state surveillance or the near ubiquitous non-state soft surveillance, whereby monitoring of social media, consumer activity, smartphones location occurs on a routine or daily basis. Third, in an information society in which the use of data can affect all aspects of daily life, the decisions made on the basis of data analysis can have significant human rights implications. For example, predictive analytics may be used to identify high risk and therefore high cost individuals, affecting their access to health care or the affordability of health assurance, while decisions made on the basis of data analysis may equally affect individuals' access to employment or credit. This may result in direct discrimination. Discrimination may also be indirect and unintentional. Indirect discrimination occurs when your apparently neutral laws or policies lead to consequences that, without justification, disproportionately affect individuals who share particular protected characteristics. For instance, predictive analytics may be used to determine individuals' suitability for a particular health case intervention. If the underlying algorithm does not incorporate human rights requirements, this may result in indirect discrimination. There's been examples in the US of real estate firms who completely unintentionally have sent black people to one suburb and white people to the other, using those sort of analytics. So an ostensibly neutral algorithm may disproportionately affect individuals of a particular socioeconomic background, thereby further disadvantaging the disadvantaged. To avoid indirect discrimination, the decision-making process must take human rights obligations into account. These examples illustrate how the use of ICT and big data may result in a wide range of human rights violations. Potentially affected rights include the right to freedom of expression, the right to liberty, the right to health, the right to work, the right to the highest attainable standard of living, and the right to equality and non-discrimination. So it's not just privacy. They may also undermine the achievement of the Sustainable Development Goals, affecting, for example, the efforts to combat poverty, improve health and well-being, and reduce inequality. Now, just so we're all clear, poverty in those terms is $1.25 a day, so that's not an issue in New Zealand, but inequality is. So it's impossible to look at the opportunities provided by the use of ICT and big data in isolation from the challenges posed. A holistic approach to internet governance that overcomes the digital divide through greater informed and consensual participation while protecting against risk is required. The potential of ICT and big data to facilitate the fulfilment of human rights and the achievement of the SDGs, coupled with significant potential harm associated with their inappropriate use, underscore the need for a human rights-based approach to the governance and use of ICT and big data. So if you're interested in a better understanding of the human rights implications of the SDGs, you Google the Danish Human Rights Institute SDGs and you will find a brilliant analysis by goal, by target, and linking to every human rights instrument. And the other critical international guidance to have regard to is the United Nations Guiding Principles on Business and Human Rights. Just give me a rough idea, if you put your hand up if you know about the United Nations Guiding Principles on Business and Human Rights. Okay, so there's three pillars. One, governments have a legally binding obligation to ensure no business in their jurisdiction does human rights harm. Two, business has a non-legally binding obligation to be responsible and to organise its affairs so it does no human rights harm. And pillar three, the government has to have judicial and non-judicial remedies if harm is caused, and business has to have non-judicial remedy systems if harm is caused. And they've been in place since 2011, and they are coming down the track very rapidly to a place near you right now. Many of the larger companies in the world, there are 100 companies operating in New Zealand that does have a human rights policy. ANZ does have a human rights policy. It does do human rights due diligence. It does understand the UNGPs. And most of the banks do, but not everyone in New Zealand does. And just finally, I'd just like to acknowledge the importance of the work done by the New Zealand Data Futures Partnership. The issues around democratic or social licence to operate, ethical arrangements for data use, a system-wide approach, future focus, acting as a sounding board and forum for trusted independent cross-sector guidance on data issues will be critical to ensuring no human rights harm is done in the use of data. And that's what that partnership is there to do. We strongly support the 4 data use principles of value, trust, inclusion and control. And the trick of standing upright here is training people to do the right thing rather than say the right thing. It's the doing that counts. So I think that's a lot. Thanks a lot. So just any questions?